We will hear argument this morning in Case 23-1122, Free Speech Coalition versus Paxton. Mr. Schaefer.
Thank you, Mr. Chief Justice, and may it please the Court. In this case, a Fifth Circuit majority held that mere rational basis review, the most lax form of judicial scrutiny, applies to a Texas law that burdens constitutionally protected speech based on its content, specifically by imposing an age verification barrier before anyone can access a sexually themed website. That aberrant holding defies this Court's consistent precedent, including its Ashcroft decision, as Judge Higginbotham well explained in his dissent. This Court should begin by confirming that strict scrutiny continues to apply to any such content-based burden on websites and their adult users. Notably, Texas's law is even more problematic than its failed federal predecessors. It applies to entire websites, depending on whether 1/3 of their content is deemed inappropriate for minors. It also brands websites with stigmatizing, unscientific so-called health warnings that, despite being enjoined, evidence Texas's intention to deter adults, even assuming they've cleared the age verification hurdle, from accessing protected speech. To abandon strict scrutiny here, Your Honors, could open the door to an emerging wave of regulations that imperil free speech online. From there,
Destiny, would this only apply to Texas? So when you're going before the Supreme Court, what you're trying to figure out is does the law as written comport with the language of the Constitution such that this law is permissible? So let's say that Texas goes to the Supreme Court with this law restricting access to porn websites, and let's say that the Supreme Court justices write, they say, hey, this is actually not constitutional. You cannot have a law that restricts access to pornographic websites in this way. We think that this is not constitutional. If that's the case, then any other state that has a similarly worded law, I don't know if those have to be challenged or if they automatically go away. My guess is the states would just repeal them or stop enforcing them, or I don't know, maybe there has to be a challenger, but like it would mean that the rest of those laws are likely to disappear soon as well, unless they're done through a different mechanism that would also probably be challenged eventually the Supreme Court or whatever. If the Supreme Court upholds the law restricting access to porn sites, then it might be that other state legislatures feel emboldened to pass more laws like this. So technically, this only applies to this particular law in Texas, but when the Supreme Court is making decisions about conflicts or potential conflicts between the Constitution and state laws, the statements that they make there matter for the entire country, right? Because it tells all of us what the court is going to view certain laws like.
This Court can readily.
What's more likely to happen in your opinion? I don't know enough about this case to even know. This sounds like it's going to be similar to the TikTok one, where a lot of the debate comes down to what the standard of review should be. So it sounds like in here, it sounds like the Fifth Circuit. So the Fifth Circuit is your first federal court of appeals that covers a range of states that include Texas, and I think it's known for being more conservative. This is your Fifth Circuit court, your first court of appeals, your Fifth Circuit. So the next step is the Supreme Court. Apparently, this court held that the law as passed or as written by Texas did not burden fundamental rights and didn't implicate any suspect classes, meaning that the law didn't have anything to do with the First Amendment, and it's not like cutting off access from classes of people that ought to be protected. So rational basis review means that as long as there's like a reason for the law to exist at all, then it's probably going to be okay. And obviously protecting children is a really good reason. So it would be allowed to stand under that level of review. So the plaintiffs here are probably going to argue that it should be a strict scrutiny review because this implicates the First Amendment. And if it implicates the First Amendment, then the state has to make a much stronger argument for banning access to pornography for minors or for putting these types of restrictions on. I don't know what is the correct argument because First Amendment stuff is like very complicated, and I don't know anything about the details of this case. I have no idea.
Restore the preliminary injunction given petitioners' likelihood of success under strict scrutiny. The district court found that this law's age verification provisions are wildly under-inclusive and unduly chilling. At the same time, content filtering today affords at least one alternative that is both less restrictive and more efficacious. Ashcroft teaches that a preliminary injunction should stand in precisely these circumstances. That result, Your Honors, does not denigrate government's compelling interest in protecting children, nor does it prevent Texas from trying to carry its burden between now and final judgment or from enacting a new and better tailored law. Rather, reinstating the preliminary injunction would simply maintain fidelity to First Amendment rights and precedents while litigation proceeds. I welcome the Court's questions.
Can age verification systems ever be found constitutional?
Justice Thomas, I think government should start with content filtering as a less restrictive alternative.
But can age verification ever be constitutional?
I don't think the court needs to close the door to that here, but it would need to be tailored age verification of the sort that the amici supporting Texas are advocating, which is different from what Texas's law permits.
And what would that look like?
I think, Your Honor, what you have from the amici is that there are ways of verifying age short of identifying the individual, short of the transactional data that Texas would require be provided. And so you would have less identification of the individual. You would have privacy protections that are maximally assured by the law. You would have private rights of enforcement that you do not have here. Everything depends upon the Attorney General, who's avowedly hostile to these websites and to their users. And last, Justice Thomas, you should have confidentiality that is legally assured. And the state should be providing assurance that it will not misuse the information that is being collected pursuant to the state mandate. None of those features are present in Texas's approach to age verification. And tellingly, you have...
I'm so sorry, I'm not familiar with the lower cases at all. Is Texas collecting information on people that are using the verification systems to view pornography? Is that true?
That the amici supporting Texas are advocating, which is different from what Texas's law permits.
And what would that look like?
I think, Your Honor, what you have from the amici is that there are ways of verifying age short of identifying the individual, short of the transactional data that Texas would require be provided. And so you would have less...
That Texas would require be provided. Fuck me, I don't know the law on this. Fuck, is there a link to like Texas law Texas law restricting pornography? Fuck, can somebody find me a link to this law? I'm curious how it's written. Ugh, what? Fuck Google, dude. Okay, House Bill 1181. Texas. Okay. Liability for allowing minors to access pornographic material. Commercial entity includes blah, blah, blah. Distribute means to issue, gives a minor. Individual younger than 18 years of age. News gathering organization includes an employee of a oh, I don't care. Okay, reasonable age verification methods. In this section, digital identification means information stored on a digital network that may be accessed by a commercial entity and that serves as proof of the identity of the individual. A commercial entity that knowingly and intentionally publishes or distributes material on an internet website or a third party that performs age verification under this chapter shall require an individual to, 1, provide digital identification, or 2, comply with a commercial age verification system that verifies age using a government-issued identification, or B, a commercially reasonable method that relies on public or private transactional data to verify the age of an individual. Provide digital identification. What are the, okay. What part of this requires them to, what part of them requires us to turn any of this over to Texas? Or were they just saying that that could happen or whatever? They're saying it isn't ruled out explicitly? Okay, well, all right.
Identification of the individual, you would have privacy protections that are maximally assured by the law. You would have private rights of enforcement that you do not have here. Everything depends upon the Attorney General, who's avowedly hostile to these websites and to their users. And last, Justice Thomas, you should have confidentiality that is legally assured, and the state should be providing assurance that it will not misuse the information that is being collected pursuant to the state mandate. None of those features are present in Texas's approach to age verification. And tellingly, you have nothing in the legislative record, you have nothing from Texas, even in its submissions to this court, that shows how the specific provisions of HB 1181 have been tailored with sensitivity to the privacy concerns that exist in this context, or for that matter, to actually being efficacious and making sure that you have meaningful protections that protect minors across the board. And so, Your Honors, if we start with strict scrutiny.
Counsel, can I ask you a question?
Oh, actually, never mind. I guess what we just looked at was the law, or the act, a bill to be in a title act. So this is just the law, or whatever. But I guess the way that the Attorney General enforces it could include them saying, well, we need a record of IDs or something. We need a record from these sites to ensure that the law is being enforced, that they would have the So this is just the law as written. I guess theoretically, the state attorney general could demand that they get that information from sites. Okay, and maybe that's what they're referring to here, maybe.
Is it a barrier? Explain to me why the barrier is different online than in a brick and mortar setting. I mean, in a brick and mortar setting, it seems like a lot of your concerns are driven by privacy concerns, which are really a feature of the internet. I mean, you don't have privacy if you go into the bookstore in Ginsberg, or if you go to a movie theater that displays pornographic movies. You have to show age verification. So explain to me why this is so uniquely burdensome here when it's not been in the real world context.
Let me start with that, Justice Barrett, with your question about why is this medium different. And the answer is you're creating a permanent record on the internet. Let me start with that, Justice Barrett, with your question about why
It sounds like he's calling her Justice Bear. He's saying Bear, though.
is this medium different? And the answer is you're creating a permanent record on the internet when you provide this information, that it is being collected, it is a target for hackers, it is something that is different from just flashing an ID in physical space. But I'd also note that you have content filtering, as the court has recognized, that is the analog in the physical space.
Well, I mean, let's see. In Ashcroft 2, the court, expressed anxiety about the fact that technology moves so fast that the 5 years between the district court findings in that case and the case being at the Supreme Court, that technology may have moved beyond the record at that point. It's been 20 years since Ashcroft. The iPhone was introduced in 2007, and Ashcroft was decided in 2004. I mean, kids can get online porn through gaming systems, tablets, phones, computers. Let me just say that content filtering for all those different devices, I can say from personal experience, is difficult to keep up with. So, and I think that the explosion of addiction to online porn has shown that content filtering isn't working.
So, Justice Barrett, let's flash forward on the technology. I think it is actually common ground that content filtering today is technologically better than ever, more readily available than ever. It's employed by this court, it's employed in workplaces throughout America, and it's agreed by the experts for both sides that it can work, specifically in this context of parents protecting their kids through all the devices that Your Honor just cataloged. You can find that in the
This court has an IT department, and so do workplaces.
But this is content filtering software that's designed to be implemented in the home. And so if you look at Joint Appendix 275, 76, 282, 285, you can see Mr. Allen testifying for Texas about content filtering today being fit for purpose. It's a question of adoption. And as to that, I think it is telling that Texas has not considered the possibility of educating parents, encouraging parents. There was a proposal as to this law, specifically to say that devices would automatically install content filtering. That would be legally required. They dropped that. Texas dropped that without any explanation whatsoever. You can find that in the Joint Appendix at 255, 56. Texas decided that they would empower parents and equip parents, and then without explanation decided they would skip ahead to this very chilling step.
Mr. Schaffer, do you know a lot of parents who are more tech savvy than their 15-year-old children?
Justice Alito, it's a fair question, and I don't know that I think kids may be ahead of parents, but that's a problem with this law. It's not solving for the fact
Well,
that
it's a problem with filtering, isn't it?
I don't think it is, Justice Alito, because this is filtering software that is designed to withstand circumvention, including by sophisticated tech people in the workplace and in courthouses.
I mean, Mr. Schaffer, come on, be real. There's a huge volume of evidence that filtering doesn't work. We've had many years of experience with it. We now have...
Fuck. I just stopped going to Pornhub in Florida. I'm going to be honest. I'm so sorry, Pornhub. Because as soon as I see the ID thing, I'm like, fuck this. I'm too lazy. I'm honestly, but who in the middle of masturbating is like, oh, let me go get my ID? Who the fuck has time for that? However, my guess would be that content filtering probably would be harder to get around than just ID. No? Like, if let's say that my parents give me a phone and that phone has like a content filter on it by default and it can only be unlocked with the parent's password, you would need the parent's password to change the content filtering. But if it's just an ID requirement, if you get your parents, if you go get their like driver's license or something and type the info in, then wouldn't that be an easier way to bypass? Or is there a different way? I'm trying to think of what would be easier to get around. I guess you could get around theoretically either one, but I feel like the content filtering would be much harder to get around, especially because like a content filter could literally be linked to a parent's email address. And then anytime it's changed, you get an email as the parent. Like that would be the simplest thing ever, no?
Many, many states who have adopted age verification requirements. You think they just, well, why are they doing that if the filtering is so good?
Respectfully, Justice Alito, they made no efforts to encourage content filtering or to educate about it. And look, Justice Alito, at the health warnings that are in this law. Those are designed to change established behavior.
Those are not before us. Is your argument that this is unconstitutional because it was...
What was that insanely dog shit argument from Alito? What? If content filtering is possible, why are other states banning based on you are using age verification? Who the fuck cares? That's not the question before this court. And I don't think we're evaluating any of the record of those other cases. Well, I mean, these are just oral arguments. He could just ask that question. That's a fair question. I'm sorry. That was mean. I just hate Alito. That's a fair question, I guess. Never mind.
Requirements. You think they just, well, why are they doing that if the filtering is so good?
Respectfully, Justice Alito, they made no efforts to encourage content filtering or to educate about it. And look, Justice Alito, at the health warnings that are in this law. Those are designed to change established behavior.
Those are not before us. Is your argument that this is unconstitutional because it was motivated by improper bias in the part of the Texas legislature that voted almost unanimously for this law?
I would suggest that to Your Honor, but I don't think you need to go that far. What I would say is that they wanted to skip ahead to the more chilling efforts to change behavior as opposed to starting with content filtering or even considering it.
But the point is that content filtering may work to some extent, but it doesn't work to the same extent in achieving the government's interest. At least that's the argument. And the relevant inquiry is not, does content filtering work? It's, does it achieve the interest to the same degree? As Justice Barrett indicated with Ashcroft.
I'm so curious how technologically sophisticated these arguments get, because in here, I would argue that content filtering, I feel like would almost certainly be more effective than this ID requirement, because The ID requirement just means that people just go to different websites, and you're completely lost at that point to any sort of regulation, right? I'm sure there are porn websites that still work that you can go to that don't have this ID requirement. You just go to the sites, and it's over. But with a content filter, you could theoretically be updating this list like all the time, and the software and the update, whatever server we're connected to check for updates would have complete control over that. So it would be more effective there if your goal was to keep somebody from going to some pornographic website, right?
Justice Breyer's opinion in Ashcroft, whether it was right or wrong at that moment, seems correct today, or at least prescient today.
Justices Kavanaugh, Alito, Barrett, I would encourage you to look at the district court's findings in the petitioner's appendix 112 to 114 about all the gaps in Texas's approach to regulating. Foreign websites are going to be completely undeterred and unchanged.
Too, yeah.
You have VPNs that tech-savvy minors can use to make it seem like they're outside of Texas. You have search engines. You have social media. All of those are designedly outside the scope of Texas's law, and the only way that kids are actually going to be protected from all those many sources that are the most readily available.
Well, that's an under-inclusiveness argument, and I don't think we've said that as a state has to tackle every aspect of the problem, or else it can't do anything.
Well, but you're being burdensome to people that aren't necessarily targeted by this law. So if your law is not effective, because if it is a strict scrutiny case, and even in an intermediate scrutiny case, you have to show that that law is not unnecessary. I don't know what the word, I should learn. I need to know the exact terms. Is it like that it's narrowly tailored? I don't know if this is only for strict scrutiny or if this applies to intermediate scrutiny as well, but it has to be narrowly tailored, and it should be the least restrictive means of accomplishing a desired objective. So if this is overly restrictive because it applies to me, an age class that it's not protecting, and if it's not even accomplishing the desired objective, right? It's failing on both of these counts. The law is not tailored in an appropriate manner, and it doesn't even advance a compelling government interest. So
all I mean to suggest is that a genuine effort, a serious effort to regulate in this area would look like the federal laws that Your Honors were considering that said, irrespective of source, there's certain content that is sexually explicit and inappropriate for minors, and that
What do
is
you mean by
the subject of the law.
genuine and serious? You don't think they're genuine in their interest?
I think that they're genuine in their interest, Justice Kavanaugh, but I think that their interest is a broader anti-porn interest in preventing willing adults from accessing this content. And they want to make it more difficult, they want to make it costlier, they want to make it chilling. And so, Justice Kavanaugh, what I would say is, crediting the court's concerns and the concerns of a responsible government that wants to regulate here, I think you should wait for a government that actually shows they're making serious headway to tackle the problem.
Could I take you back to Justice Barrett's initial question? And this was about brick and mortar stores. And if there's an age verification requirement about like porn magazines, is that also subject to strict scrutiny? Are you saying that should be analyzed the same way?
I need to see the law, Justice Kagan. I would. I think if it's an age...
No, I don't think you need to see the law. It's just this. It's an age verification requirement, but it applies to brick and mortar stores, and it relates to the distribution of, printed smut.
Here's all I mean, Justice Kagan. If that law was to say age verification takes the form of an affidavit or show your birth certificate, I think that would absolutely, of course, be subject to...
Well, it's an age verification law that requires the same kind of documentary proof or whatever that this law does.
I think if it's going beyond the New York law that was addressed in Ginsberg, as I understand Your Honor's question, I think it would be subject to strict scrutiny. It would almost surely satisfy that scrutiny unless it was gratuitously designed to chill the adult customer from making the...
And why is it that law would satisfy strict scrutiny, but this law does not?
Because it's tough to imagine, Justice Kagan, how else you would be getting after the point of purchase exchange to a minor, short of what Your Honor is describing, assuming that this is the kind of traditional sort of law. I do note we agree with the institute.
Right, when he's saying it would be difficult to imagine how else you could even do this, right? So this is the least restrictive means, right? How else could you possibly, you can't really do content filtering in real life of real life people. You probably have to check an ID. There's just no other way to know, right? So
if that's the case, your answer to that really depends entirely on content blocking, the availability of content blocking in the online space.
I don't think entirely, Justice Kagan, because if you go to a store and the clerk is just looking at an ID, there's not a special cost associated with that. When you have age verification for every single user in the internet context, and you're multiplying those costs, $40,000 per 100,000 users as found by the district court at a minimum, you have a serious burden on the speaker. And we agree with the Institute for Justice in its amicus brief that when you have a law that reads as this law does, saying if you are sponsoring sexually explicit content online, you must answer to an across-the-board age verification mandate. That, Your Honors, is content-based discrimination. That is a content-based burden. That should always trigger strict scrutiny.
Well, the court...
I'm sorry. I just want to pin you down a little bit if I can. I'm going to try.
So here there is a potential category of unprotected speech, obscenity, but there is a dispute about that. We'll see if this comes up. I don't know if whether or not this is even considered protected or unprotected speech. I don't know if that's if the court is considering that or not.
Do you agree that, at least in theory, brick and mortar institutions shouldn't be treated differently than online and vice versa?
Shouldn't be treated differently? Well, that's weird. That's like saying, should minors and adults be treated differently under the law? I mean, technically, They have different categorizations of the law, but they're both treated the same by the law. But that's a very strange question. How does he answer this?
That principle that we shouldn't have a constitutional regime that prefers one technology over another. We said as much in Wayfair.
Justice Gorsuch,
do you agree with that principle?
I think it's a different medium, so I don't want to be difficult with Your Honor's question. I do agree. Oh, sorry.
I'm going to press you. All right. I understand they're different media, but does the principle apply that we should try and treat those two media as equally as possible?
Yes, and I think in a way it is.
I'll take it.
Okay, he says as equally as possible. That's true. Sure. Okay.
I'll take it.
Okay. I'll stop there.
Yeah, good idea. Okay. What percentage of your clients' materials would be considered obscene for minors?
Your Honors, it's tough to arrive at that
Well,
calculation.
your friends on the other side say it's all.
I don't think, no, that is not true, Your Honor.
Virtually all?
No, Your Honors. If you
Okay, then you give me the number. What percentage?
I cannot quantify it because we're dealing with, I would recognize, a very large universe of material. I would note, Your Honor, that among that material is blogs. It is podcasts.
I understand. I'm asking you for percentage.
Your Honor, I cannot quantify that.
More than 50%?
I think that's a fair guess.
More than 70%?
Your Honors, I don't want to go out on a limb. I think that may be correct, but I can't tell you with assurance.
More than 90%?
There, Your Honor, I think we may be stretching upwards.
Okay,
as far as whether it's sexually explicit.
We got 70% though. Okay. All right. And then do you agree that there is a compelling government interest in keeping obscene materials for minors?
Absolutely, yes.
Unequivocally.
There has to be, yes.
Why don't you, to follow up on Justice Gorsuch's questions, why don't you talk about the most popular porn sites, which I gather you're representing? So one of the parties here is the owner of Pornhub, right?
Yes.
And what percentage of the material on that is not obscene as to children?
Destiny, they're talking about the percentage of obscene material because it's unprotected. That might be true. Well, I don't know if I agree. I feel like if obscene material was totally unprotected, then it would be in the prerogative of I imagine it would be in the prerogative of the plaintiffs here to try to downplay as much obscene material as possible, right? And it sounds like he doesn't care much about identifying it. Or maybe does it have to be 99% obscene, or maybe you only need 30% protected material, or I don't know. I imagine that's the thing that'll come up more here, right?
Well, Your Honor, if we're talking about the youngest minors, I would agree that most of it is, and that is how we read it.
Is it like the old Playboy magazine? You have essays there by the modern-day equivalent of Gore Vidal and William F. Buckley Jr.?
Not in that sense, but in the sense you have sexual wellness posts about women recovering from hysterectomies and how they can enjoy sex. That's on there. Discussions of age verification proposals and where the industry lines up as far as what they think should be legislated and what should not.
All right, let's go down to what's the second most popular.
This might be a dumb question, but what is the government's interest to prevent children from consuming pornographic content? When you're talking about the state's interest or the government's interest, we're a democracy, you're talking about the people's interest, right? The state is seen as being empowered by the people. It's not like a question of like national security or whatever. When we say the government's interest, we just mean like, what are the people's interests? Like the government has an interest in preventing crimes because we, the people, have decided that there are crimes that we want prevented, right? We talk about the state's interest, the government's interest. I mean, we, the people, have an interest in not having children accessing or being exposed to obscene material or pornographic material, I think.
Popular porn site.
Your Honor, I don't have the.
You don't know you represent these people.
We represent the industry, Your Honor, the portion of the industry that answers to U.S. laws and jurisdictions. So
Are you familiar with what they have?
Your Honor, somewhat so, yes, and I think the record offers some indications of that. But I'd also note that some of it is softcore by any account. It's people who are wearing less rather than more clothing we would recognize, but not anything that anyone would think to be obscene as to adults. And potentially for a 17-year-old, that would be up to a parent to decide what's appropriate for their minor.
I mean, the district court was worried that this would have an effect on something like Netflix, right?
Yes.
I mean, is Netflix a party here?
No, they're not. But
is there anything in any business other than hardcore porn, a party here concerned about the application of this law?
Is that a valid concern that people have? In the USA, yes, right now, I think it's illegal to show pornography or anything to a minor. That's considered a corruption of a minor, or it could be, I don't think you would call it, I think you would call it corruption of a minor, right? As if if an adult was sending or showing pornographic material to an underage person, a minor.
To them.
Yes,
I'm sorry, an amicus here.
Well, Your Honor, you have the American Booksellers Association. You have O Schools, which is devoted to sex education.
You don't have Netflix. You don't have anybody else like that who is concerned that this would apply.
And even in terms of the client base, Justice Alito, I want to be precise. One of the client websites is solely softcore. It's not anything that you would, I think, would answer the description you were suggesting earlier. And they are absolutely going to be brought within the sweep.
Counsel, can we get to the question presented? The question presented is not whether this law passes is constitutional. The question is what level of scrutiny, correct?
Correct.
And so the issue that Justice Gorsuch asked you was, what type of scrutiny should we apply when content can be obscene as to children, but not obscene as to adults, correct?
Correct.
And we have at least 5 precedents that have answered that question directly.
Yes.
In Sable, some of the material was obscene to children, even if it wasn't obscene as to adults, because with respect to children, we have said that even indecent materials can be regulated under rational basis, correct?
Yes.
And in Sable, the law applied to adults, and we said you had to apply strict scrutiny.
Correct, and it was invalid under it.
So,
this is what Pisco was talking about. Okay, so Pisco was correct, I think.
Even if it wasn't obscene as to adults, because with respect to children, we have said that even indecent materials can be regulated under rational basis, correct?
So when she says indecent materials can be regulated to children under, display to children can be regulated under rational basis, it sounds like what she's saying is indecent materials to children can be considered obscene, and obscene content is not stuff that is protected by the First Amendment, meaning that if you want to make a law against obscene material, you're not implicating a fundamental right that would raise it to the burden of a strict scrutiny analysis. So if I wanted to say, you're saying fuck Congress, and you put that on a billboard, that's just like offensive speech, but it's not obscene, to make a law against that, it would be, I imagine, a strict, I don't know if the fuck word is obscene or not, but it would be like a strict scrutiny analysis. But if it was like pornography on a billboard, that's obscene material. You have no guaranteed free speech protections. If the state wants to take it out, they just provide any reason whatsoever, so it would be a rational basis review. So then the obscene question, I think, probably is really relevant here, I would imagine, in arguing for the level of scrutiny you'd want analyzing this law.
Yes.
And in Sable, the law applied to adults, and we said you had to apply strict scrutiny.
Correct, and it was invalid under it.
So the answer to Justice Gorsuch is, let's treat every medium under the scrutiny that applies to the people affected, correct?
Yes, Justice Sotomayor.
So that's strict scrutiny.
That is strict scrutiny.
For us to apply anything else would be overturning at least 5 precedents.
That's my count as well. And
all right, now, let's move from there, okay? Assuming all of the questions that have been asked of you, whether because this medium is different, more ubiquitous, whether because the effect on children might be greater today than it was back when, that would go to whether strict scrutiny is met. Isn't that true?
that is exactly right.
And so if content filtering is no longer as effective as we thought in Ashcroft, and I spot my colleagues that that's likely true, that would go to whether this law meets strict scrutiny because age verification is more effective, correct?
Yes.
All right. Now, having said all of that, there has been a suggestion by the other side that instead of strict scrutiny, we should apply intermediate scrutiny. Assuming we applied a different level of scrutiny, I don't know.
So that's interesting. If the other side is arguing for intermediate scrutiny, then that means that, is it just because age is implicated, or are they saying that this is First Amendment? No, I don't know the answer here. I think anytime the First Amendment is implicated, it's automatically strict scrutiny. So if they're trying to say it should be intermediate scrutiny, it sounds like they're just talking because a quasi-suspect class is implicated. Maybe? I don't remember. I don't know the actual.
I don't know why, because the only 2 times that we've applied intermediate scrutiny, one was Renton, where they were dealing with the effects unrelated to speech, correct?
Correct. Secondary effects.
Secondary effects, traffic jams, noise, et cetera. But the one case that might give me pause is Pacifica. All right? In Pacifica, it had to do with the radio. And we applied a different level of scrutiny because of that. But it wasn't rational basis like this court did, correct?
Correct.
So it was at best intermediate scrutiny.
Yes.
Why is this different than Pacifica?
2 reasons I'll offer, Justice Sotomayor. Number 1.
Standard review determines the Constitution of content-neutral government regulations that limit speech, government limitations on the content of commercial advertising. Okay, under many the government has prudent significant government interests, regulation narrowly tailored. Example, alternatives for communication. Okay, so under intermediate scrutiny, reasonable content-neutral time, place, or manner regulations are permissible.
And broadcast is uniquely regulated as a medium of expression, as the court has recognized, and public broadcasting in particular. The internet is the opposite of that. Through all the precedents Your Honor went through, Reno and Ashcroft, and the way that the internet is developed. The second reason, the court emphasized just how much radio permeates the entire house. If the radio is on, you may just hear something. So there's no analog for content filtering, and you don't have a user through the screen who is specifically electing certain content. And I would just note, Justice Sotomayor, in Pacifica, it was even-handed across-the-board regulation of the content deemed inappropriate for kids. Here you have what Justice Kavanaugh and I were discussing in terms of under-inclusiveness. I would say it is so conspicuous, so inexplicable, it is speaker-based discrimination that is another reason, in our view, why strict scrutiny would apply here, even more so than in the cases we were just going through. Sorry, Mr. Chief.
No, thank you very much, counsel. Sable, of course, was 35 years ago. In that period, the technological access to pornography obviously has exploded, right? I mean, it's very difficult for 15-year-olds, whatever, to get access to the type of things that is available with a push of a button today. And the nature of the pornography, I think, has also changed in those 35 years. And so are those the sort of developments that suggest revisiting the standard of scrutiny is something that we should at least consider, as opposed to keeping a structure that was accepted and established in an entirely different era?
I'd respectfully urge you not to, Mr. Chief Justice, and for the same reasons that Your Honors did in the Holder case, in the UE case, and opinions that you wrote, Mr. Chief Justice. The extent of the interest does not change the standard of scrutiny. It simply goes to whether the applicable scrutiny is satisfied. And we are here conceding explicitly that there is a compelling interest that is at work in this area. We encourage state efforts to regulate in a way that is properly tailored, is respectful of adults' rights, and is really going to help protect kids. And so that, Your Honors, is exactly where strict scrutiny does its work. And I think for the reasons that we were discussing with Justice Sotomayor, it is as well warranted here as in the entire string of cases where Your Honors have continuously applied strict scrutiny, even as there were new problems, new technologies that government was trying to tackle.
Thank you, Counsel. Justice Thomas? Justice Alito?
Justice Sotomayor mentioned some of the precedents that have been cited by the parties in this case. She didn't mention Ginsberg versus New York, which was perhaps the decision that the Court of Appeals relied on most heavily. So I would like you to explain why rational basis was appropriate in Ginsberg and not appropriate here.
I don't know anything about any of these cases, so I can't speak to any of them. But
what you say in your brief is, the law at issue in Ginsberg did not place any restriction on adults' access to sexual materials. It did not, for example, require sellers to conduct age verification of adult customers. How can that be true? Suppose a youngish-looking person went into Mr. Ginsberg's store and wanted to buy a girly magazine. Mr. Ginsberg faced the possibility of criminal prosecution if he did not verify that that person was not a minor. So why is there not age verification built into the issue in Ginsberg?
Justice Alito, if it's built in, it's tailored age verification, just as you were suggesting with the question. Most purchasers, if I myself were the purchaser, I don't think I would be carded. The New York law said that if there was a knowing sale to a minor, or someone whom the seller should suspect to be a minor, that was the exceptional instance where you might have, subject to the seller's discretion, some reasonable effort to ascertain the age.
Well, that's why it's so important to know. These guys really know the underlying material. Although I imagine pornography is probably one of the more studied areas, I guess, if you're talking about like standard of review and freedom of speech, because like this is always where the borders of your freedom of speech are probably tested, are around things like obscenity or adult material or pornography or protection of children. This is probably where like you hit a lot of the edges of freedom of speech, I would imagine. So my guess is going to be, I don't know, my guess is going to be like all of these cases are probably pretty well studied or pretty famous for people that constantly fight about pornography or freedom of speech.
If what you're facing is possible criminal liability, you may want to err on the side of safety. I know that when I try to buy wine at a supermarket, they require me to show an ID. I take it, I'm flattered by it.
I've had the same experience.
That they might be required to check your ID, but that doesn't speak to what the criminal statute is or what prosecutors prosecute on. Because I think like in Vegas, even they don't always, but usually in Vegas, they will card almost everybody. But in a lot of supermarkets that I've been at, they literally have a sign in it. It's like, if you look like you're under 35, they'll card you. My guess is going to be the specific intent mens rea is going to be the that you have to knowingly, or that there's some obligation placed on you, or you're acting in like a grossly negligent manner when you sell alcohol to a minor. So that'd be my guess. I don't actually know, I guess, but maybe they'll talk about specific statutes. The one that he referenced earlier in that Ginsberg case, it sounded like that New York law said you had to knowingly sell, or you should know better to sell to a minor for alcohol, I think.
But Justice Alito, I don't think the senior citizen under the New York law would be as likely to be asked to produce verification of age, and it certainly wasn't an across-the-board age verification mandate that has costs and burdens.
Counsel, I think we're off on a tangent.
Sorry.
Let me move on to something else. So you agree that the state has a compelling interest, but you say they have other ways, less burdensome ways of serving that interest. And I just wanted you to go through those. So one is filtering. We've talked about filtering. Another that you referred to in passing was putting some kind of a blocking device on every device. You want this built into every smartphone? Is that the idea?
So it's available. Yes, Justice Alito. Right there at the click of a button.
Why is that less burdensome?
First of all, it's not burdening speech. It's the conduct of producing the device that's subject to the regulation. You also don't have someone, when they're accessing extremely sensitive content online, merely by virtue of that, going through a separate transaction where they're identifying themselves in a way that is specific to that content, the most sensitive, private, compromising content. And
you don't want, your clients don't want to pay for it. You want to put the cost on Apple and Google, right?
Well,
That's what's involved.
I also note it's not a tax on the speaker, which has been a traditional paradigmatic concern of the First Amendment. Here, it is the speaker of the particular expression who, by virtue of that content, is subject to the tax.
So it sounds like, I don't know, I don't know any of the, would you say jurisprudence, like the prior decisions or whatever the fuck? I don't know, like where the precedent, maybe you would just say. But it sounds like he's saying that, like, let's say in order to buy porn, you have to get like a special license to buy porn. You would say like, okay, well, to some extent, you're literally singling out the people that are accessing a certain type of content to get a particular thing. And it sounds like this would be less likely to pass than saying everybody needs an ID and you can check that ID to see if you get porn, because it's not just subjecting the people accessing this type of speech or whatever to a particular burden or whatever. Yeah, I think.
What other ways of furthering this interest do you think the state should have adopted?
Two more. You could have blocking at the internet service provider level, subject to the election of the adult who's in charge of the account, so that you could have it cut off at the source so it doesn't flow into the household unless the adult has authorized it. And the other, as I was discussing with Justice Thomas, if the state is to pursue age verification and the court is to suggest that that is open to the state, notwithstanding the availability of these other alternatives, let them do that in a way that is well considered and tailored, so that the age verification process is no more burdensome than it needs to be. You have guarantees about what that age verification looks like. You have privacy protections. You have confidentiality. You have enforcement mechanisms that are available to the aggrieved private party. This law, HB 1181, does not answer to any of them.
There are services that provide age verification for lots of, and they are used for lots of purposes, for online gambling, for purchasing tobacco products, and they have very tough privacy limitations built into them. Isn't it open to your clients to use those?
Actually, it's not, Justice Alito, because if you look at Petitioner's Appendix 171, you can see the provisions of the law that govern age verification. It has to be one of three things. Either a digital ID, which everyone agrees is not available in Texas, so that's the number one alternative is not there to be used. The second is a government-issued ID, which everyone agrees is exceptionally chilling, perhaps the most chilling way to identify yourself to a hostile government. And the third is dependent upon commercially reasonable methods that rely upon transactional data, Justice Alito. So that's things like your mortgage application.
So you could not use Yoti, for example. Your clients could not use that.
We don't think so, Justice.
What is Yoti?
By all indications, that is ruled out. And I do think that that's telling. You have Yoti's amicus brief, but they don't pretend to marry up their proposed forms of age verification with what Texas has prescribed and by implication proscribed as an available form of age verification.
Is that something that's been addressed by the Texas courts or by the Texas AG, whether using a service like that would satisfy the requirements of the statute?
I think the plain text tells us you can't. Texas didn't suggest a narrowing construction below, and of course this was a pre-enforcement challenge that resulted in a preliminary injunction, so there just isn't an opportunity there to have the narrowing construction. One other point, if I may, Justice Alito, there have been hacks of age verification providers. That is a real thing, despite all of their assurances. And Yoti, as you'll see in amicus briefs.
That is quite the chilling effect, right? Like, was it Ashley Madison? Like, that website was hacked, and wasn't everything stored in plain text? This is like 10 years ago, I think, or maybe like 5 or 6 or 7 years ago. Like, everything was dumped from that site. The idea that there might be like www.incestanalporn.com or some shit, and you have to like, I have to show my ID. Yes, here's my ID, my address, and everything. Yes, here you go. Thank you. Like, oof, that's like a really, you want to talk about chilling effect. Whew.
In support of us.
There have been hacks of everything.
Yes. And that is exactly why age verification has an inherent chill to it. Everyone knows what Your Honor just said.
Justice Sotomayor?
Ginsberg, and that's what the court below relied upon. Ginsberg was a child
Yes.
objecting, not a store.
Exactly right, Justice.
And it was a child saying, I shouldn't be barred from viewing indecent materials because adults shouldn't, correct?
That's correct.
And so the only rule there was what level of scrutiny do you apply to a law that applies only to children, correct?
That is exactly right.
And what the court said is what's indecent for an adult could be obscene, basically, for a child. And obscene materials only have to, for children, obscene or indecent materials only have to satisfy rational basis.
So she's saying obscene or indecent material. So I don't know how they do these classifications. Pisco's saying there's a Supreme Court case, apparently Miller v. some fucking loser. In the Miller case, there's a 3-point test to determine if material is obscene, and obscene material is not protected by the First Amendment, meaning that if you want to ban obscene material, it's incredibly easy to do so if you have any reason whatsoever to do it. Basically, that's rational basis. And indecent material, whatever classification that is still something that I think calls on First Amendment protections, but indecent material shown to children becomes obscene material, meaning it has no First Amendment protections. That's what it sounds like.
That's right. And I would just note that Justice Brennan's opinion for the court was exceptionally clear about what you were just going through, Justice Sotomayor, what was and was not being addressed.
So in terms of Ginsberg being a precedent, it's not a precedent involving a burden on adults.
Yes,
Correct.
And our challenge is solely on behalf of adults. We are not invoking the rights of minors.
Sable was a case in which there was a burden on children and a burden on adults. The court applied rational basis to the burden on children and explicitly applied strict scrutiny to the burden on adults, correct?
Oof, okay. So cases are important here.
Correct?
Yes.
So we have direct precedent that says you will apply different scrutiny to each age category.
That's right. And I would just note that in Reno, Justice O'Connor's separate opinion there differentiated, just as Your Honor is suggesting, between the rights of minors versus the rights of adults, which were separately addressed in that opinion, too.
Justice Kagan? Justice Gorsuch?
I had thought Ginsberg was a conviction of an adult who sold to minors, and it wasn't a minor asserting any rights. He was charged and convicted of crime knowingly selling to minors, right?
Damn, all these motherfuckers got opinions on Ginsberg, Supreme Court ruling. Ginsberg v. New York, 1968. Appellant, okay, we're just going to do real quick. The appellant, so the person who appealed this case all the way up here, who operates a stationery store and luncheonette, was convicted of selling girly magazines to a 16-year-old boy in violation of Section 484-H of the New York Penal Law. The statute makes it unlawful knowingly to sell to a minor under 17 any picture which depicts nudity, which is harmful to minors, and any magazine which contains blah, blah, blah. Okay. The appellant's conviction was affirmed by the appellate term of the Supreme Court. He was denied leave to appeal to the New York Court of Appeals. Ginsberg v. New York. Okay, this is a Supreme Court case, right? Yeah, okay. Oh, sorry, because I do this backwards, sorry. His conviction was affirmed by the appellate term of the Supreme Court. The Supreme Court in New York is not their highest court. I think that's their first court of appeals. And then he was denied leave to appeal to the New York Court of Appeals. So this is New York's highest court, the Court of Appeals. And then it went to the Supreme Court from there, I guess? Okay. Held. The magazines here involved are not obscene for adults, and appellant is not barred from selling them to persons 17 years of age or older. Obscenity is not within the area of protected speech or press. There's no issue here in the obscenity of the materials involved, and appellant does not argue that the magazines are not harmful to minors. It is not constitutionally impermissible for New York under this statute to accord minors under 17 years of age a more restricted right than that assured to adults. The state has power to adjust the definition of obscenity to apply to minors, for even when there is or where there is an invasion of protected freedoms, the power of the state to control the conduct of children reaches beyond the scope of its authority over adults. Constitutional interpretations has consistently recognized that the parents' claim to authority and the rearing of their children is basic in our society, and the legislature could properly conclude that those primarily responsible for children's well-being are entitled to support of laws designed to aid discharge of that responsibility. The state has independent interest in protecting the welfare of children and safeguarding them from abuses. This court cannot say that the statute defining obscenity on the basis of its appeal to minors under 17 has no rational relation. So it sounds like he was trying to challenge the law then. He wasn't contesting any of the facts. He was trying to challenge this particular law. Oh, but I guess that makes sense, right? The Supreme Court won't review facts of a case. They just go over the laws. Okay, sorry. All right. Fuck me.
I had thought Ginsberg was a conviction of an adult who sold to minors.
Correct.
And it wasn't a minor asserting any rights.
Correct.
He was charged and convicted of crime knowingly selling to minors, right?
Forgive me for agreeing with both you and Justice Sotomayor. The challenge.
Only one of us can be right.
Well, here's how I square the circle. It was a challenge.
He's asking the litigant to solve a dispute between him and Sotomayor. Okay. Spooky, base.
By the seller, invoking the rights of minors. So that was what the
he was
court
invoking
presented.
his right to sell to minors.
Just of course.
He was convicted of a crime for knowingly selling to minors, counsel.
As was presented. I square the circle. It was a challenge by the seller invoking the rights of minors. So that was what the court presented.
He was invoking his right to sell to minors.
Just.
What? Don't make me. I can't. I don't have time to read this case right now, and I don't ever want to read this case. I don't have time. There's so many other things to do. Is that what he was invoking? Was he invoking his right to sell to minors, or was he invoking the rights of minors to say that minors ought to be allowed to consume? Because either way would probably win the case, obviously, right? Because if he strikes down the law as unconstitutional, saying that minors have a right to consume obscene material, then it strikes down the New York law. But if he says he should have a right to sell to them, even if they don't have the right to consume it, then it would free him up of any legal obligation. I don't know what they were making. I don't know what the arguments were. So I can't take a side here. Whatever.
Yes, of course.
He was convicted of a crime for knowingly selling to minors, counsel.
As Your Honor knows, in the First Amendment context, the availability of the overbreath challenge can invoke the rights of others, and that's exactly what I understood per Justice Brennan, the challenger there to have done, invoking the rights of the minor.
Okay. You agree he was challenging his criminal conviction for knowingly selling?
I'm not going to disagree with the procedural march, Your Honor, just the substance.
And your distinction of Ginsberg is there. He didn't have to check every ID. Is that your distinction?
Correct. Liability arose from a knowing sale.
So you think that a law that would require brick and mortar stores to check all IDs would be impermissible?
I think it would be subject to strict scrutiny, potentially, if the adult shows the sorts of burdens that we have here. Then I think.
And you would argue that undoubtedly that it chills, and therefore it's a problem, right?
Just of course, my arguments would not be anywhere near as strong. I don't envision any such challenge, and I don't know of any such challenge being brought. I'm not suggesting the court should write its opinion here in a way that invites those challenges.
And with respect to age verification online, which you treat as a different kettle of fish, gambling, age ID is required by a lot of states.
If it's not involving expression, protected expression, I'm not bringing the First Amendment challenge.
Applying to get a gun, Second Amendment, got to do that online?
Different standard. We're not concerned with children the same way. We don't have all the precedents that call for strict scrutiny when you have burdens on adults and the concerns that are operative.
The vote in some states, you have to show an ID, a government-issued ID?
We're not suggesting that's at issue.
Okay, all those are okay, but this is different.
Your Honor,
okay. Why would it be burdensome to show an ID or chilling to show an ID to vote. There's a compelling state interest there. It can theoretically be narrowly tailored in a way that like you feel like you need to do this. Yeah, I don't think it's quite the same now.
It is different. And I think part of it's because of the internet, part of it's because of the law, and part of it's because we're talking about a content-based burden on the speaker.
Okay. And then we do have an amicus, from the age verification provider saying that this can be done now online, anticipating and talking about Justice O'Connor's very thoughtful concurrence in Reno saying this technology is going to change. And they say it indeed has changed. And you point out that we don't have much of a record, given that this is on a PI. What do we do about that?
I think it was incumbent upon the Texas legislature to make a record and show that it was wrestling with these considerations.
Or is it incumbent upon the challenger to the law, especially in a facial challenge, to make the record?
I think under strict scrutiny, it's Texas that bears the burden. It is a content-based burden on expression. You have the instruction of this court that was clear as can be in Ashcroft and no consideration by the Texas legislature about content filtering. So I think that gives us likelihood of success out of the gate. But I would also note, Justice Gorsuch, as found by the district court, we showed that age verification, as implemented by HB 181, will chill and will be invading privacy. One last point. This is a one-third trigger. And what Your Honor's positing is a more targeted law, a more tailored law that says here's a particular concern and we're regulating according to that.
When he says facially, he just means like banning certain types of porn, and I think that's his favorite type that he likes to see.
And then,
actually, I think good mute. Facially, I think he's saying like on its face, who does the burden come from? Like, shouldn't the burden be on the plaintiff to show by the record that this is like not constructed properly or something like that? And then his argument is, well, obviously, if it's a strict scrutiny thing, then the burden is actually on the state. The burden would be on us if it was rational basis, but it's on the state. So the burden is them to show that they have a reason to do this, right?
A more tailored law that says here's a particular concern and we're regulating according to that.
And then what do you do about our statement in Moody that those who bring facial challenges have an especially hard row, not road, row to hoe?
Yes. We think we've done what Moody's would require any First Amendment challenger to do. We've shown that the heartland applications are unconstitutional, particularly when it comes to lack of tailoring. As you expand beyond these particular challengers, who are the avowed targets of the law, the analysis only gets worse for Texas. We don't read Moody's to have transformed First Amendment jurisprudence so that you can never bring a First Amendment challenge when you're dealing with certain unknowns and a wide array of speech that's being regulated.
I don't know anything about that.
Justice Kavanaugh?
On Justice Sotomayor's questions about what's before us, is it just whether we apply heightened scrutiny? Do we go on to apply heightened scrutiny? You, in your opening, asked us to restore the preliminary injunction. In order to restore the preliminary injunction, as you are asking, we have to make an
We have to what? See that you're likely to succeed on the merits of your case?
assessment of likelihood of success on how the standard is applied, not just what the standard is, correct?
Correct, Justice Kavanaugh. So I'm respectfully making that ask of the court, but we recognize you could stop short.
Okay.
So when they're asking for an injunction is they're trying to stop you from doing a particular thing. What is it? There's two things you can ask for. You can either get an injunction or you can get a stay. A stay is you're prolonging a thing from taking effect. I think an injunction is you're telling somebody to stop doing something they're currently doing, right? So there's a law that's already in effect. So you're asking for an injunction saying we need protection from the courts so that Texas fucks off. And he's trying to get, they're trying to get an injunction against that because it's already being enforced and fucking them, I think. So asking for an injunction means we want to pretend that this law is not in effect, make them stop doing this while the case goes through, but you have to show that you're likely to succeed on the merits of your case in order to qualify for an injunction.
And do you dispute the problem that Texas is targeting of children's access to pornography?
We don't dispute the underlying problem.
Oh, slightly different standards. PSCO says slightly different standards. I don't know if the slightly different standards are written out in law, but I've heard, I don't know how true this is, but I've heard that like getting a stay is a lot easier than an injunction because a stay is basically saying like, hey, we're just kind of like kicking the can down the road here. Let's just like chill for a little bit. But and a court is more likely to say like, okay, well, let's put this off. But an injunction, the court has to like intervene. It's an injunction, right? The court has to actually come in and say like, hey, you can't do this particular thing that you either have a right to do or you're already doing. So you're more likely to succeed, I think, asking for a stay than for an injunction. I don't know how that applies here at like for this level of like litigation or whatever, but and then TRO is temporary restraining order. I don't know anything legally about how TROs work.
We support efforts to solve the problem as long as they're properly tailored.
Do you dispute the societal problems that are created both short-term and long-term from the rampant access to pornography for children?
Justice Kavanaugh, that is a complicated question that I don't know that I can speak to definitively. I would say this. I think that there's a discussion, a robust discussion, and a healthy discussion about whether all sorts of things involving screens and the internet and social media and interactions over the internet, whether those are unhealthy for children. Okay. And we understand that this is part of that discussion. I just don't think it's confined, as Your Honor was suggesting with the question, to pornography.
And then thinking back to Ashcroft 20 years ago versus now, age verification technology has become cheaper, more effective in preventing circumvention. At least that's what is represented to us. Do you dispute that?
I think that the technology has evolved. We don't dispute that. I think the forms of age verification that are built into the law are absolutely susceptible to cheating because you can get the supposed proof of age.
The question was whether it's improved since the time of Ashcroft.
I think that it has improved, Justice Kavanaugh. I don't know that it's fit for purpose, but it has improved.
And then European countries, France and others, are requiring age verification for this kind of thing.
Your Honor, they have explored it. I would note that the UK has actually...
A TRO is like a PI, but it can be granted without the other party even appearing in court ex parte. Ex parte? Oh, okay. Huh.
They suspended age verification pending technological developments. And they do not, to the extent that they require age verification, the way that they're doing it looks fundamentally different from Texas because, as Your Honor knows, Europe builds in all sorts of ferocious privacy protections and penalties if there are violations.
That's a fair point there. On the change in technologies, how do we evaluate the ubiquitous nature of smartphones that did not exist at the time of Ashcroft?
I think it tells you that this law is not going to accomplish its aims because the smartphone can access the foreign websites. It can you can use VPNs at the click of a button to make it seem like you're not in Texas. You can go through the search engines. You can go through social media. You can access the same content in the ways that kids are likeliest to do. And HB 1181, by its design, does nothing. I do mean nothing to address that.
Yeah. And again, I'm asking those questions because you are asking us to restore the preliminary injunction, and therefore we need to have some sense of those questions.
I appreciate the question.
Yeah, and last, on stare decisis, because that's been raised appropriately, how do we think about stare decisis with a case like Ashcroft as to its evaluation of the facts on the ground as opposed to its legal standard articulation?
I think Ashcroft was exactly on point because it was predictive. It was not the court saying definitively that here is the way of the world for all time. And
do you think it's permissible for the court to say, you know, looking at it now with the technology as it's evolved, with the smartphones, with the experience of the problems caused by children's access to pornography, that we now essentially agree with Justice Breyer's evaluation of how to apply the standard?
Respectfully, no, Justice Kavanaugh.
And why is that?
Because of the posture we're in. We're here on a preliminary injunction.
Likelihood that we would agree with Justice Breyer.
Well, but Justice Kavanaugh, I think the district court has work to do as reflected in its undisturbed, unchallenged, well-substantiated findings about what the record says about these.
Would you agree
to
restore a preliminary injunction by this court? We would have to find that you have a likelihood of success on how whatever level of scrutiny is applied, correct?
I have a friendly amendment to that. You would find that the district court did not abuse its discretion by so concluding preliminarily in predicting likely success based upon a preliminary record. That's exactly what Ashcroft addressed. That's exactly what Your Honors have before.
Fuck me. Okay, I don't have time to listen to this. Fuck. What is the government's arguments? The state of Texas is the defendant here, right?
But the argument he was making, I think this is clearest on 636 case.
And change in the technology of brick and mortar stores.
They'd be able to satisfy strict
Or to the possibility of it satisfying strict.
go to the Fifth Circuit of age. But there's a lot that we think are questions of what the law means, where everyone agrees the Fifth Circuit was wrong to apply only rational basis review because
in minor. The government says just decide that the wrong level of scrutiny was applied here and send it back to the Fifth Circuit to apply it. You say, no, we should be applying the standard for strict scrutiny. And I think that is what is opening the door to all the questions that you're getting about whether or not this is actually narrowly tailored, whether or not there are, content, the content filtering software is working. It's because it seems to me that you've asked us to apply strict scrutiny, a circumstance in which it would have been easy, as the government suggests, to just.
Oh, this is not Texas, but the amicus? Okay. Amicus is a party that can come in and basically be a support character, defend you because they don't have to be a party to the lawsuit or have standing. I don't know how you prove or what kind of standing an amicus needs actually. How do you decide if amicus curiae is approved? What does that mean? Parties. Amicus curiae brief in a case for the court for oral arguments may be filed if it reflects that written consent on all parties, if all parties have been provided, or if the court grants leave to file under subparagraph 3b of this rule, the brief shall be submitted within 7 days after the brief of the parties supported is filed. Motion of consent. Fuck me, this is too much. Don't care. By the parties. I don't know how you decide if these are allowed or not, but okay. Destiny, they have none. They're just here. They're just there to give their opinions to the court. Yeah, but there must be a limit or a way to qualify, right? Like we couldn't all just write amicus briefs for whatever case and have them all accepted by the court. I imagine you couldn't just have 20 written, right? So there's got to be a way. There's got to be a way to determine what's allowed or what's not allowed, right?
Say wrong standard, Fifth Circuit, and send it back.
I never want to be disagreeing with the United States unless I must. So we don't have much disagreement with him on this.
Fundamental principle. Here, though, there's a specific category of speech defined by its content, speech that is obscene as to the minors, where everyone agrees that the state not only has a legitimate interest, but a compelling interest in making sure that minors do not access that speech that is defined by its content. So I think it's going to be much easier for states to show that restrictions that are based on that content are narrowly tailored to a compelling interest.
But will it be easy enough for this law to pass?
I don't know about this law. We haven't taken a position on that.
I know, but I mean, you've been staring at this law for a long time, and this law is pretty similar to 20 other laws that are out there. So you must have some sense, even if you don't want to say particularly this law. There are 20 laws out there. Are some of them going to pass through the eye of the needle here or not?
So let me say, if the question were framed the way Justice Thomas did, is there some version of age verification that is good enough? My answer is yes.
I'm not really talking about some imaginable version. I'm talking about like some version that states have enacted.
So let me give you a specific example. We defended COPA, the law this court looked at in Ashcroft 2, even after remand in the district court in the Third Circuit and in a cert petition in this court. I have no reason to think that we would come to any other conclusion about a law that looked like that today. The reason I'm hesitating about state laws is that I don't know that there's actually that much variation in the state laws, and all of them raise some questions that we have about Texas's law that we think are questions of what the law means that would inform the First Amendment analysis. So one is this 1/3 requirement. I think petitioners say the law requires age gating of an entire website, even if it has a substantial amount of content that's protected. My friends from Texas say in the red brief that if you segregate out the obscene as to minors content behind an age gate, you don't have to age gate the rest of the content of the website. That seems highly relevant to us. The second one is the issue that my friend alluded to earlier about which methods of age verification are allowed. The amicus briefs in Texas.
I'm so curious. How does like because maybe the law has to do with like a percentage of. I didn't see that. I don't know what Florida's looks like. But like, what about like Reddit or Twitter? Because there's not safe for work material on those sites, right? I know there is on both of them. Is that age gated or something in certain states, or?
This highlights some of these newer biometric methods that seem significantly less restrictive, but there's a question, as the colloquy earlier illustrated, whether Texas law would allow those methods or would instead require some sort of physical identification or transaction records of some kind. And then the last one, which has also already come up, is which minors are we talking about when we say obscene as to minors? I take it that the plaintiffs say that means obscene even as to the youngest minors. When we were defending a similar law in COPA in Ashcroft 2, we took the position that obscene as to minors means obscene as to all minors, as an inappropriate and lacking in value, even as to older minors. I think the law becomes much easier to defend if Texas courts would adopt the same interpretation of the Texas law here.
Older minors, my favorite.
If I could add one thought, I think that this court has said in a series of recent First Amendment cases that tradition can be a very important guidepost in deciding both what standard of review applies and also in thinking about how to apply that standard in particular circumstances. I think here the tradition that applies in brick and mortar contexts that's reflected in Ginsberg, to be sure, but also in a much broader family of laws that restrict the distribution of this material, as Justice O'Connor explained in footnotes 1 and 2 of her opinion in Reno, adult theaters, adult bookstores, books and magazines. There's a long tradition of restricting this material through age verification methods that are less formal because, as Justice Alito indicated, it's just a requirement. Don't sell to minors, and that means that a clerk in the physical world can do it by looking at the person and only requiring ID if the person isn't obviously of age. But there's a long tradition of imposing age restrictions on the distribution of this material. So I think that supports the idea.
And on that point, Mr. Fletcher, I mean, so you do take Ginsburg to be more than we're just dealing with the rights of minors. It does also impact how we think about the burden placed on people, adults, to ensure that minors don't have access. It speaks to that, as do our traditions with respect to adult theaters and many other things.
I agree with that wholeheartedly as to the tradition that's reflected in the law that was an issue in Ginsburg. I think.
I'm also curious, how do you define 1/3? Like, let's say that I have a website where there's one naked picture. It's called www.yourmomsdick.com. And it's got one picture of your mom's dick, but then it has like a million pictures of a cat or different cats. But like 80% of the site's traffic is just to see your mom's dick. Does that count as 1/3? Is it 1/3 of the content hosted? Is it 1/3 of the visitors? Is it 1/3 of the bandwidth consumed? Is it 1/3 of the unique visitors? Is it like, I wonder how they even define that. I think they bring this up because technically softcore porn is not illegal to sell to minors, which is why the non-legal NC-17 rating exists. Oh, that's true. Actually, it's not illegal for minors to consume rated R material either. And I think rated R can have softcore, like simulated sex as well, right? I think all the old horror movies had like simulated sex scenes, right? And none of those were NC-17. Those were all rated R, right? Oh, so that would just be indecent but not obscene? Jesus. Yeah, I don't know how this is like a whole fucking area of First Amendment shit that I don't know enough about. But okay. I'm recording another podcast tonight with Decoding the Gurus, our best friends. But I have to do this ground news insertion ad or they're going to kill me. I was supposed to submit this for review like 3 days ago, so. Hold on. Are there any other features of this that I need to know? Oh, what is the site also has a blind spot checker. NC-17 is a policy of the American Film Association, not a legal basis. No, but it only exists because of the laws in the U.S. What I mean by that is like you couldn't make a movie rating that would allow you to show a 17-year-old hardcore pornography. That wouldn't be allowed, right? So those movie ratings are not necessarily like legally codified, but the law has a carve out apparently for softcore porn, or rather it carves out hardcore porn as being obscene material, I guess, for children. Well, but then I guess softcore porn isn't even indecent material, which is weird. I don't know. Oof. Is this middle thing like the most biased stuff, or not necessarily? Federal judge allows red states to resume lawsuit against mifepristone? Mifepristone? I don't know how to pronounce. About abortion. Nobody on the right wanted to cover this, apparently. Oh, but there's only 10 news sources, so I guess it's not that hot of a topic. It's Plan B. Ooh. I feel like I could actually incorporate this site into my content. I feel like there might be interesting shit. On the blind spot part. What are only liberals talking about and what are only conservatives talking about? FBI shuttered DEI office last month. CNN defamation trial. Judge criticizes CNN's lead counsel, requests apology. Nobody on the left wrote an article about this. Although 70, it sounds like only 10 articles were written about this. Okay, just kidding, 16. Wait, 7 leaning right, 3 leaning left. How are there 16 sources? Damn. Wait, were there just no stories about this Treasury Secretary, or did they just like specifically carve this out as a as just about minimum wage? Maybe that was just about minimum wage. I guess you can tell which ones are contentious or not, huh? Because nobody partisan is writing about Scott Bessent, which was the U.S. Treasury guy. But then if we look at, what was it, Pam Bondi? We have a lot of partisan opinions about this from the right and left. Okay. Well, I'll love you guys. I'll be back tomorrow. Stay safe. Ribberino, cappuccino, pappuccino, hoppuccino, moppuccino, cappuccino, 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 dinner. Is that what you guys? Next. Wait. Ooh, tomorrow we talk to P.F. Young. That'll be fun. Be careful.